the facets of understanding Food Safety and Standards Act 2016 is always an intriguing subject. But if you have someone like R Srikanth, who is an executive director legal in Sanjiv Goenka Group, retail and FMCG, you can understand who has the practical nuances and understanding of the subject, and who is a known speaker. In fact, he's a dear friend of mine. And in one of the posters, when I saw that Mr. Srikanth has his knowledge in this particular aspect, I had requested that, despite the fact that I'm so close, I was never knowing this body. So he said that he's more like a cocoon of a butterfly. Now you can understand how you can move forward with those aspects, and you can see the better colors and better understanding regarding the food safety, including the standards. As we always speak, that being a weekend, we always make a request to the speakers that the topic should be short, crisp, and precise. And needless to add, Srikanth has this excellence, and that's why he has reached. Off late, he has been promoted to the designation of executive director, which speaks volume that he executes things in the right way and the right perspective. Over to you, Srikanth.
Thank you, sir. Thank you. First of all, I congratulate the services you are doing, especially to the law fraternity. And as we all learn from looking at your YouTube channel and your sessions. So coming to the today's topic, Food Safety and Standards Act. I know that none of this our law school curriculums or any university curriculums, we don't have food safety as a subject. So once you pass out and you're working with the industry and you need to encounter many issues related to food safety. So why it's important to learn the food safety? If I slice it in terms of economy, is food safety, the Indian processed food industry is 470 billion. If we have 3.7 or 4 trillion economy, it's almost 12 to 13% of our market size is the food safety. And the law related to the food safety governs this big industry. Of course, there are no practical avenues to learn this, as it is not part of the curriculum. So what we learned over the last 20 years while working with the Food Safety Authority of India, and this law has been enacted in the year 2006, but it came into force in 2011. So I was fortunate to be part of these various committees which was drafted this act as well as rules and regulations. So prior to this, just I'll give a summary. This is the area how I present this, the small introduction, why we require law, why the laws are consolidated, what are the licenses requirement, what are the duties of food safety officer, and more importantly, as a lawyers, we need to know how the sampling process and adjudication process will conduct. So food safety. So before I start this, we need to understand the terminology. And recently I was reading a newspaper where it was mentioned that one flight, I was carrying more than 200 passengers on board, was flying in some foreign airspace. Suddenly it encountered some in trouble in the engine. So that pilot desperately messaging the local ATC asking for the permission to ground. The ATC refused the permission because it is not safety for any flight to give a permission to land. So he was requesting for 10 minutes. He said that my fuel is for another 20 minutes, otherwise we'll collapse. But the ATC is not giving. Then immediately he radioed a message saying that I am invoking code red. The moment he said that I am invoking code red, the ground floor ATC has immediately given permission. So the reason why they are given permission means both have spoken the same language, where in case of emergency, in case of need, they need to speak the particular terminology so that they can understand. Otherwise, it can be an alien force or some other force. So the point I was want to make is, unless we understand the subject and the terminology and the circumstances which led to the passing of this legislation and the practices of the industry, we could not able to do the justice. So with this background, I can say that food safety is not a new thing. Although the present law is codified or it was legislated in the year 2006, but law is existing more than 2,200 years. The first source of these references come from Arthashastra. Arthashastra has the provisions related to punishment for adulteration of food. So there are various provisions for adulteration of food and the consequences and then the punishments. In fact, if you go back to the Mughal era of 1,000 years or 1,200 years ago, there was certain labs was established to test the food safety, the quality of the food, and the safety of the food and the procurement. There are certain rules was set up in the period of the Mughals, and they even appointed a separate department for the food. So this law has been there since last 2,000 years. It has evolved and came into a current shape. And again, if you come to the modern India, then we can say that before independence, each state has a separate law. Suppose if you talk about the Punjab has a Poor Food Act. If you go east, you have a Assam Food Act 1990, Assam Food Adulteration Act 1919. If you go to the presidency towns, be it Calcutta, be it Madras, and be it Mumbai, they have separate food adulteration acts. In fact, every state, almost every state, even Orissa has the one act. United Provinces has the separate act. So these all separate acts are because, as we know, that food is a part execution is at state level. Every state has their own law. Whereas after the independence, the first legal framework has started from the Constitution. A specific provision in the Constitution we can see in the directive principles of the state policy, where it states that it is a responsibility of the state. It is the responsibility of the state to ensure quality of food. So thereafter, there was no specific reference to the fundamental rights, but in case of Center for Public Interest Litigation versus Union of India, this is the case of famous pesticides in aerated beverages. Like you have the cool drinks, what we call in normal generic name cool drinks. There was a pesticide residue. There was a big furor some 25 years ago. So that case was filed against the industry by the Center Public Interest Litigation. During the judgment, the Supreme Court has observed, rather it was stated that right to life encompasses the right to have a quality life and right to have a quality food. The safe and quality food encompass the fundamental right. So this was the judgment of the Supreme Court. So it has further strengthened the legal provision that a right to have safety and right to quality food is the fundamental right. So after this, after independence, after constitutional support, then center has legislated a common law for all states and entire country, including the union territories. So the state first common law came in the year 1954. Of course, implementation from 1955. The first central act was Prevention of Food Adulteration Act came in 1954, and it was there till 2011. So during this more than 55, 60 years, this law was governing. Why this required? Why this law need to change or rather repeal? A new law need to bring into force? We'll discuss them then. But one thing I'd like to mention that we all know that under criminal jurisprudence, unless you have a mens rea, no criminal act will be casted against the person who is committed. But in case of Food Safety Act, there is no requirement of mens rea. If it is some act has been happened, whether it's act of an adulteration or it act of unsafe food, the person whoever sells, a person whoever manufactures or packs, he will be responsible, irrespective of whether he has a mens rea or not. We all, as I said, we all know that the main ingredients for any offense is the mens rea, but this is an exemption to this. There was a famous case law. Someone already challenged this provision. In the matter of Andhra Pradesh Grain and Seed Association, they have challenged this. They say that we are a honest traders and we have no intention to cheat either customers or the government, and they have filed a petition challenging the infringement of their fundamental rights, Article 14 and Article 19. The Supreme Court has, after a lengthy trial, has stated that rather it is because this law is a welfare act, it requires to have a right, the customers will have a right to have a quality and safe food. Accordingly, the liability has to be fixed irrespective of whether you have a guilty of mind or not. So mens rea is not applicable in the case of Food Safety Act. and they still the same principle exists even in the new law also. This is the one fundamental difference between the other laws and the Food Safety Act. So after this Food Prevention of Food Adulteration Act, there are many issues because during last 50 years from last 1950 to 2000, there are many changes has been technological advancements, improvements in food, new category of food has come. Earlier, food means only the right immediate consumption, but we have nutraceuticals, we have other vitamin related foods, and many other categories of foods came due to the technological invention. Accordingly, the old act, that is Prevention of Food Adulteration Act, does not able to cater the entire requirements, whereas the other technological development like increasing the lab sizes, increase the quality of analysis, all these areas made a requirement, rather necessity, for bringing a new act which need to address all categories of the questions related to the food safety. So the current act, which is Food Safety and Standards Act, which was came into existence from 2011, and this repealed all the old acts. So earlier, one more thing, there was no central authority. Each state execution is at state government. So each state has, some states, the municipal corporation was the responsible for execution. Some case, some public health department. In some state, there's a health department. So there was no uniform execution. So that if you cross 50 kilometers or 100 kilometers, there is a different set of rules, a different set of practices. So considering this, there was a central act brought into the force, and this act subsumed all existing acts. So earlier you have these many acts. You have food products order for foods, you have vegetable order products order for vegetables, you have oil alert for milk, we have different thing, edible packaging oil. So everything subsumed and merged into one single act, that's the Food Safety Act. Under Food Safety Act, there are various regulations they are framed. See, every time it is difficult to amend the act and bring in some amendments to the act. So it has passed through the entire legislative process up to Parliament. So in order to expedite or ease in the process of ease of doing business, so some power has been given to the authorities where they can regulate and they can issue the regulations in accordance with the main act. So there are various regulations has been framed. Most importantly, this is Food Safety Licensing and Registration Act and Package Labeling and Packaging Act. These are the main acts which governs across the board. But we have other acts like alcoholic beverage regulations for one industries, organic food regulations for another industries, and audit regulations for certain kind of industries which required to be audited. And advertisement, those who advertise their products on various medium, so they need to comply certain regulations. So each category they defined, they diversified the regulations according to the industry and according to the category. In between, we have a regulator came into the force, that's the Food Safety Standards Authority of India. It is based at Delhi, and all states are part of that. And fortunately, I attended a couple of Food Safety Authority meetings as a special invitees. So the regulator now has become a facilitator, because we can see this earlier there was implementation, execution was different, but now that regulator has taken the shape of a facilitator. So any regulation before they start, that will be discussed at length, and the public comments will be invited, and thereafter the regulation will be passed. It's not like that today they passed and immediately they'll came into force. They'll give sufficient time to the industry to consume the existing inventory. In case of any amendments to the labeling display regulations, they'll give considerable time so that the existing inventory is exhausted. Or in case of any new regulations or any new amendment, they'll give sufficient time for the industry to adjust, accommodate, and they can build the capacity during that process. So one aspect that, and they're continue evolving this, and very user-friendly regulator, what I can say this. So as I said, we have a one central act, you have a rules, and you have a regulations. So various regulations addresses each and every specific category of the food or for the industry. So this is about the structure and background of the Food Safety Act, why we require and what is the process. So what it governs. See, we have an act, but what it does. So it regulates your food, your consumption of the food. The food is there are two types of food. One is the primary food, one is a secondary food. Primary food we immediately consume. A secondary food it is basically it's agriculture commodities which go into the processing and thereafter it's going to the manufacturing, then it go into the packing, then will come to your dining table. So this is a different process. One is you immediately you cook and you eat. So this is a processed food. So entire this thing, so this law covers the entire food, irrespective of whether primary food or secondary food. So what areas it covers, if I need to specify, there are many definitions, but if I need to specify in the four quadrants, first is it covers about your adulteration, it covers any substandard food, it covers any misbranded food, and more importantly, it's about unsafe food. One thing we need to understand under the earlier act, under the Prevention of Food Adulteration Act 1954, even a minor offense, suppose you buy a packet of biscuit, suppose date of manufacturing is not mentioned, or date of expiry is not mentioned, under old act, it's a simple 6 months imprisonment. And another is unsafe. Unsafe, it has to go to criminal trial. We'll see in subsequent slides. So first, what it all covers? It all covers all adulterant food. What is adulteration? So adulteration is if you are using any product which is alternative, I can say in a simple English, I can say is an alternative. For example, instead of, if you take any pepper, if someone is adding dried papaya seed powder, is an adulteration. If you take edible oil, if someone is adding some mineral oil and making a product, making an oil pack, then it's an adulteration. I'm giving a simple example because this is a lengthy examples as given in the definition. Similarly, in case of milk, if you see milk is a common adulterant is the water. Similarly, in case of ghee, you have a vegetable oil, it can be added as the alternate. And coffee powder, you will have a tamarind. So these are the adulterants. Another one, substandard. What is substandard? The definition, textbook definition is here, but I'll see give you an example of substandard. Suppose ghee. What is ghee? In South we call nehi, in some other place, but that's only a generic name. But what is the composition? If I say ghee, ghee means what the act says that it should have 99.5% milk solids. Similarly, if I say about the paneer, so what is paneer? Paneer means if you take any piece of product of paneer, the minimum milk solid should be 50%. So what the balance 50% can be a water and moisture. Unless a product of paneer which has more than 50% of milk fat, it does not qualify to be called as paneer. It can be some other product. It is not adulterant, but it's a substandard. There is a difference in adulterant and substandard. Adulterant, you have one other alternatives coming, substandard, so it is being diluted, or it being less quality. Then misbranded. Misbranded, if I say in simple example, if I say something, take a common misbranded is honey. So we say pure honey. Maybe it contains not exactly pure, it is from the extracted from the beehive, but there's a alternates being added, but it's not pure. Similarly, if I take any other pure milk, it's not pure if it's a processed, if it is adulterated, if it's not natural. So misbranded is basically a misleading statement where the consumer behave. Or else I can say that this famous oil, canola oil, olive oil came from Spain, but in fact it is coming locally manufactured. So I'm putting a misbranding this claim. And lastly, the unsafe food. Unsafe food means where the product, the whole product is injurious. The famous unsafe food, now what we see in seasonal is your mangoes. What mangoes? Mangoes will be artificially ripened by carbide. So most of the fruits artificially ripened. So these are unsafe foods. Unsafe food is totally where there is a chance that it can cause injurious to health, or it can cause a severe foodborne illness or any other health hazard. So that's unsafe food. So the entire law governs these 4 areas. So all regulations has been made and this under these 4 quadrants only. So this is about your law and why you required and what it covers. Then what generally how it thereafter what? So thereafter, any food business operator or any food industry, you take from the small kirana shop to a large manufacturing food products industry, they all need to take certain license. Again, if you see the earlier act, if the person doesn't have a license, even for the small petty license, small kirana shop in your neighborhood, to a large retailer, to a large manufacturer, everyone has to pass through the same yardstick and same process of getting the license or application. But under the new act, there have been two bifurcations. One is person having a turnover of less than 12 lakhs per annum. They doesn't require a license per se. They only need to take a registration. Pay 100 rupees and get a registration. That doesn't require to undergo the entire process of quality check, inspection and all. And the another category of license, the state license. If any vendor or any company or any shop whose turnover is between 12 lakhs to 20 crores, they require to take a state license. And thirdly, the central license. All food business operators whose income is more than 20 crores per annum or who operates in more than 2 states, they need to take a central license. So licensing part has also been eased considering the nature of the business and the size of the business and the exposure of the business. So this is also one of the welcome changes. Rather earlier, the only one set of license. And earlier it used to take, there is no time limit for getting the license. It may take 1 month, 2 months, 3 months. There is no end limit. But under the new act, the 60 days time limit has put. In case if your license is not granted within 60 days, then it's deemed that license has been granted. And most importantly, it doesn't need to run around the offices to make an application and all. Everything you can do online applications. This is the website, Foscos. And in fact, they train most of the food business operator in the process of applying. FSSI trained the process of applying, and FSSI has given the training to train the trainer, and they have trained more than 2 lakh trainers all across the country who will handle this process of applications and all. So this is the process is very simplified, and now every vendor they have to file a returns. Of course, retailers has granted exemption from filing the retail returns, but all manufacturing, processing, food business operators, they need to file returns yearly. So this is about the license. So first, your requirement of the law, why you require, and you have a license. Then after license, then who will do? Because a large company, there are thousands of people working. Then who will be responsible for? In other words, board will be responsible. But the new provision in this law, this is different from any other law. If you see any labor act, your occupier is the responsible. If you see any companies act, your directors are responsible. But here in the case, considering the practical scenario, suppose a factory, a company has 10 factories and your director sits somewhere either in India or abroad. It's humanly not possible for him to monitor or ensure compliance under the act physically, because he physically is not aware. The provision has been given in this act is the company can appoint a nominee who is based out of the particular unit, and he can take responsibility of the entire compliances and the quality process in manufacturing the product. This is the one of the provision which is different from all other laws. So recently, this food safety has also come up with various guidelines regarding the e-commerce. Nowadays, we all do shopping e-commerce. Your 10 minutes app or 20 minutes app, your quick commerce, e-commerce now has become a quick commerce, everything. So they also need to regulate these business. So they brought various provisions and to bring into these regulations, e-commerce regulations, where They have considered everything, because the end object of this all this regulation is to provide a quality food and safe food and the welfare of the consumers. To considering, because if you are buying something on online, so you don't know when it is manufactured. If you are visiting a store, you have the chance to physically inspect the product and see the date of manufacture, date of expiry. But in case of e-commerce, you doesn't know anything. So you simply order this, whether it's manufactured or expired, or you don't know unless it's come. But considering these practical difficulties, regulator has regulated this. The FSI regulated these regulations where all e-commerce companies, they need to have a mandatory disclosure on their networks. There are various kind of e-commerce industry. One is only a marketplace e-commerce. He doesn't sell his own inventory. There are certain e-commerce platform which they own the platform as well as they own the inventory. So everyone, fundamentally everyone required to have their own food safety license. So all e-commerce company, either they need to have a registration or license, because all the entities have more than 12 lakhs per annum. So they need to have a license and they need to display all the mandatory information. What all mandatory information? Like your name of the product, date of manufacturing, date of expiry, MRP, address of the consumer care cells. In case of vegetarian food, you have one set of declaration like green circle. In case of non-veg, you need to have certain declaration that now it's a brown triangle. So in case of packaged food, you need to have ingredients, you need to have kind of additives there added. They all need to be displayed. But before implementing, they called for a meeting, and some of the e-commerce operator raised a concern, and there's very valid concern that it is not possible that every time we need to upload the date of manufacture, because the products keep on, turnover is so high that every week there will be a change in the batch, so it cannot be possible to upload all the information every time. So they are divided the two set of regulation. One is your static information, one is your dynamic information. Static information is already pre-printed information, like who is the manufacturer, manufacturer address, license number. These all static information. What is the dynamic information? Is your date of packing and date of expiry and your MRP. So these are exempted. This has to be there in the product, but rest of the information has to be mentioned on the website. If you see if you open any website and see any product, you will find the license number of the food business operator, and you will see all the declarations. This has come from last 2 years, since last 2 years, and all website, all e-commerce companies has updated this on their websites. One most important factor what also brought into these rules is that when you buy a product, the shelf life should be minimum 30%. Suppose your shelf life of the product, from the date of manufacture to date of expiry, if it is 1 year, so minimum shelf life should be 30%. 30% is almost 3.5. After 12 months, 36 means 3.6 months. So 3.5 months shelf life should be there. Or the product should have minimum 45 days. So date of expiry D minus 45. So you should have a minimum 45 days time to consume. It's not like that today you brought, a day after tomorrow your product is going to expire. It cannot be happen. The minimum shelf life has been brought into these regulations. So all this mandatory information that has to be provided on the website, free of the cost, and they also need to empanel their nodal officer, like what you have the e-commerce indemnity rules. You should have one grievance officer. Similar kind of provisions also exist here. You need to have one customer care cell who can monitor the complaints if any complaints come from the customers. All e-commerce company, they need to have the last mile regulation. Suppose you have a physical store, this schedule 4 regulation. There is one schedule 4 is part of licensing and labeling, which part of licensing and registration rules, where it says it has certain provisions of hygiene. What kind of hygiene this any food business operator need to maintain or perform. There are basically two terms. One is infrastructure related practices. Second is your hygiene related practices. So all these need to be complied by these e-commerce operators. So it is also a bounden duty on the e-commerce platform that they need to ensure that products which they list on their platform has to comply with all regulations. Because there are certain immunities or exemptions from the for the intermediaries, because some platform who operate there doesn't directly responsible for this, but these regulations has brought certain duties on the platforms also they need to ensure. And these food business operators has the right to inspect these food products which is being supplied in any entire supply chain. Any point of time or any point in supply chain, they can correct the sample and they can send the sample to the analysis. So these are the regulations which recently came in the 2020 for the e-commerce area. So the point I would like to make that the 2011, the one set of rules, in between there was a new area has been, e-commerce area has been developed. So they also address this. So this regulator is very interactive and being working for the welfare of the consumers, throughout the year. So what happened? Once you have taken the license, once you applied the taken license, then what happened? You need to periodically renew your license. Earlier, the license was for a period of 5 years. They used to issue the expiry validity period up to 5 years, but now it has been reduced to again 1 year. So the good part is that you will get a reminder from the regulator every frequently. This is your license going to expire. You need to renew this. We, as a law students, as a lawyers, we all know that Indian Penal Code, but we do have an Indian Food Code. Indian Food Code, it's in fact how this food code has been evolved or how adapted or drafted. We have a codex element, is this international standards where all food products, as I said earlier, what you call for the ghee. Ghee means, as I said, it should contain minimum 99.5% of milk fat. Similarly, each and every product, it has been defined. After a scientific analysis, the product has been defined. Name any product has been defined. If any product has not been defined, then that product is a proprietary product. What is proprietary product? If I say you take any halwa, a sweet shop, you take a laddu. Laddu standards has not been prescribed under the act, but it's proprietary food. So considering this, earlier many food business operators have different standards. One laddu of one store is different from another place, another place. There are many Indian traditional snacks that differ from each place to each place. So in between 2004, 2014 or 15, a new licensing system was brought into force. That is called product approval. If any product which is not part of this food code or not part of the food products additives, under the act you have the schedule appendix. Under the appendix, all the food products has been defined with the standards. If any product is not falling in this category, then you need to take a product approval from Food Safety Authority of India. So there was a company, Vital Nutraceuticals. They have challenged this before the Bombay High Court, and from there the matter went to Supreme Court. The Supreme Court has, in the year 2016, has been struck down this regulation, saying that product approval process is not have a provision, enabling provision in the Food Safety Act. So product approval, proprietary food can not required to have a product approval process. So thereafter, again, FSSAI brought a regulation regarding the proprietary foods. You can have any kind of proprietary foods, but the ingredients which you are using in the proprietary foods, that has to be standard. I'll take the same example of laddu. Suppose you are using the laddu, you will have a besan, sugar, ghee. If I take these are the primary ingredients, then all these primary ingredients should be standard products. The standard product can culminate into a proprietary food, but these are the standard products. Again, what are the standard products? You have the standard product defined in the Appendix B of the Act. So this is about the law. Then what Then we have a food safety officer. He is the one of the main person in the entire ecosystem of the Food Safety Act. He is the person who is responsible for inspecting the premises. He is the person who will conduct the samples, and he is the person who verify your records. And in fact, he is the interface between the food business operator as well as the authority. He has the power to enter into the premises. Like, he's a public servant, he can enter into the premises. He can seize the records if he found something is suspicious, or something is found that some adulteration process is going, or some other violation has been happening as per the act. Then he has the power to seize and seal the premises. So he reports to a designated officer. Designated officer reports to joint controller or commissioner, depends upon the structure of the state. So he is the person who investigates all the complaints which is received from the customers or which is received from other stakeholders. And earlier, in case of under the old act, any violations, either it's a seizure or cancellation of license or the penal prosecutions. But under the new act, the food safety officer has a power to issue improvement notice. Rather, he can give one opportunity to make good of the compliances which you are not complying. He can do a surveillance sampling. You can see during the festive season, you will have lot many samples. This is called surveillance samples. One is surveillance sample, one is a mandatory sample or regulatory sample. So food business operator, he'll collect the sample, he'll send them for analysis. So he'll do the all, he is the executing authority under the act, in simple words. So what he does inspection before issuing license, after issuing the license. It is also prescribed that the inspection cannot be happen at the drop of the hat, because we see that sometimes some inspections happen routinely every month, once, twice in a month, or thrice in a month also. But it's very clear guidelines has been issued that inspection need to be happen. If it is a manufacturer, it's only once in a year. If it is a retailer, a retail food business operator, once in 2 years. So there has been certain conditions has been imposed on, duties rather is imposed on the food business operator also to investigate any complaint against the food business operator. So, as I said earlier, the food safety officer has the right to inspect the premises and he conduct the sampling. All the cases related to the food safety revolve around 3 issues. One is about the sampling, method of sampling, a process of sampling, and delay in sampling. And another area is right to the food business operator to appeal. And third is the limitation. All entire litigation under the food safety revolves majorly on these 3 issues. So before sending the first, how it starts, the food safety officer enter into the premises and he has to express his intention that I am so and so, I'm coming for the inspection and I have doubt that there is certain products which are not complied with the provisions of the act or regulations of the act. So I need to send this analysis. Now the entire sampling process has been prescribed under the act. So he should call some punch witness and he has to collect the sample and seal the sample in presence of the punch witness. In case of non-compliance of this independent witness, there is no prosecution against the food business operator. Prosecution does not stand on this. This is the case of Supreme Court in Ram Lavia as the Municipal Corporation of Delhi. Supreme Court said that in this particular case, there's no witness come forward to sign the witness Panchnama statement. So, in fact, the food inspector officer has expressed his inability to correct the independent witness. Even matter went up to the Supreme Court. The Supreme Court considered that, of course, the law is very stringent, mandatory that the independent witness should be there. So he is not there. So nominal punishment of 1,000 rupees was given. If you remember in the old act, there is no provision for punishment. It's only imprisonment. But Supreme Court has given this exemption for this in this particular case. The point I'd like to make this, in case in the old act also, in the current act also, any inspection has to be done in the presence of an independent witness. We see many cases, the food inspector come along with his attendant or his peon, and he will sign the punch witness. So most of the cases will not stand before the criminal the trial before the session court because of this reason itself. So the how the sampling has to be done. Sampling, he cannot come and as it is cannot take this. So whenever he is taking the sampling, he has to collect the sample. The sample should homogeneously represent the entire population. Suppose he is taking an example of a milk. Whatever the milk is collecting, he has to stir the milk and he has to collect from the middle of the vessel. Okay, it cannot take from the top or it cannot take from the bottom. So once he collected the sample, then he need to pour that into a container. It can be a glass, it can be a plastic, but the container has to be cleaned and it has to be sterile and it has to be cleaned with a dry cloth in the presence of the food business operator as well as the punch. Thereafter, he has to seal that container. And if in case of it's a packaged food which is already packed, then he need not to open it. He can collect the packaged product as it is and he can seal it, he can send it. In case he is sampling a perishable products, what is perishable products which have a short shelf life of day or two, milk, curd, etc. If it is a short shelf life, he has to collect this in a chilled containers. So once he collected, he cannot keep in ambient temperature. He has to keep under refrigeration where the product, all frozen products need to stored in 5 to -5 degrees temperature. So he need to maintain the samples once he collected this, because he cannot keep the sample forever for his office. The next immediate day he has to send it to public analysis for analysis. So the law also prescribes the standards. So how much milk he can take, 20 gram or 20 ml of the milk or 2 liters of the milk, how much he can take? No, very clearly mentioned. These are the standards. These are the every product he has to take the specific standards. Most of the cases, again, before the trial court, he'll take 1 kg of the product and he will make 4 packets of 250 grams, or he'll take 100 ml, 100 ml, 100 ml of each product. In case of milk, he'll take 100 ml, 100 ml. So the cases will not withstand only because the quantities, the specified quantity what mentioned under regulations has not been collected. So whether these are the list of the products which acts as that has to be in the specified quantities. In case any product is not figured in this list of 24, then the product should have a specified quantity of 500 grams. So he need to take 500 grams of each product or 150 grams, whatever the net quantity mentioned here, and he need to take and he need to make the 4 samples. Why 4 samples? I'll tell you. He need to make the 4 samples, he need to pack and seal, and he need to send it to the public analysis as well as his superior. So this will be a typical, this is the practical case of the photograph of one sample. So he has to seal this. So he need to measure the code, the seal number and minimum quantities. He has to specifiedly, and he has to put a lead on it, and he need to properly seal, and he need to send it to analysis. So he need to collect the 4 samples. One he will send to the public analysis. Public analysis is food analysis. Whether he can say anyone? No. Earlier there were only 5 food CFL, Central Food Laboratories were there, but now under the new act, there are various private entities also been listed under NABL, Laboratory and Sampling Regulations. Certain as labs has been identified for conducting the analysis. Where it doesn't have a private lab, they need to send it to the government lab. So out of the 4 samples, 1 goes to the food analysis, and the 1 food safety officer will keep 1, and rest of the 2 it will be sent to the designated officer. Designated officer who will be the authority under the act who can initiate the prosecution. He is the superior of the food safety officer. So what happens when the sample was sent to analysis? The public analysis conducts is, see, the entire sampling process can be picturized in this way. First, sample is collected, then it was sent to foods analysis. If analysis conduct the analysis and is sent this analysis report and the product is in order, then there is no further action. Suppose if the product fails in the analysis, why it fails? If it is a misbranded, if it is a adulterated, if it is a unsafe, or then if it product will be failed. In that case, analysis report will be sent to the designated officer. What designated officer? He will see what is the cause of offense and what is the violation. He'll see, then he will give a right to food business operator to go for second analysis. This is the main right of the food business operator. Again, 50 to 60% of all the cases in last 50 years has been quashed or set aside because of this fundamental reason, where this is the fundamental right of the food business operator to challenge the report of the food public analysis. The famous case, Municipal Corporation of Delhi versus Gisaram in the year 1966. This Supreme Court, 23rd November 1966. If you Google it, you will get MCD versus Gisaram. That law, that still, as on today, still exists. Any case where the second analysis, the report was right to appeal, and the opportunity was not given to the food business operator, then the case itself will not stand. So what happens? Now coming back to this, once the food business from the DO issue opportunity to the food business operator to make an appeal, it's an option with the food business operator either to go for an appeal or not. It doesn't, irrespective of the fact, the matter will be filed before. If it is exercised this right for appeal, then product go for second analysis. The DO will wait for the second analysis report. If the second analysis report comes against the first analysis, then if it is a government lab, the second analysis will prevail. The no cause of action. In case the both reports found that the product fails the standards of as mentioned in the act, then case will be filed. So if I put the entire time frame, if I put that these are the main case for what any lawyer who is practicing, they need to keep in mind. These are the technical defenses which are available to food business operator in case the product fails and case is filed before a session court and magistrate court. Food safety officer has to collect the sample and immediately he need to send the sample to public analysis immediate next day. Suppose today, Friday he collected or Saturday he collected the sample, Sunday being the holiday or Monday happened to be holiday or working day, he sends on Monday. Whether it's compliance with the act, no. He has to send immediately. Upon receipt of this sample, the food analysis has to complete the entire sampling process within 14 days and he need to send the report to the DO within 14 days. In case he unable to conclude the analysis, he need to give a written request to the designated officer stating the reason for the delay, then only it can be extended. Otherwise, it is a 14 days. There are many cases. In fact, in last couple of years, a lot of cases from Madras High Court only on this case, only of this violation of this provision. Suppose in a public analysis report comes and if it is found that product is unsafe, if the product is unsafe, then the prosecution will lie before the session court or magistrate court. So the DO has to send his recommendation within 14 days. And the commissioner of food safety officer, commissioner food safety, every state has a commissioner food safety. He has to give a power to file the prosecution. He has to give permission to file the prosecution before the court. So if the entire process should complete before 1 year from the cause of action. What is the cause of action? The date of sample. From the date of sample, launching of prosecution should happen within 1 year. In case of beyond this, no case will lie. Section 77 of that very clearly says that no case will lie if there is a strict provision for limitation. However, the commissioner has a power to extend the delay based on various reasons. But the whatever the reasons, he has to clearly, the commissioner has to write himself, rather he has to under his authority very clearly depicting the reasons for the delay. This is the case of Suresh Rajput, where the commissioner has extended the filing of the case beyond the time limit, but he simply signed a cyclostat copy. I hereby extend the time by 16 more months. He has simply signed this. There was no reason were given, not the reason was given why the prosecution was launched within the time frame as mentioned by the Act. So within the Supreme Court has struck down this case, allowed this criminal petition and quashed the lower court proceedings. So time frame, the law limitation is very strictly ensured in this food case. The only reason being the food products has a short shelf life, they cannot be further assessed, and even the food business operator right to appeal has been curtailed, then it's a violation of his fundamental right. So this has been upheld by the various courts, right from High Court to Supreme Court in various cases. So considering this, both the food safety food authorities has to ensure the time limits. Correspondingly, the food business operator has to keep and watch all these time frames in order to save his defense. So there are two types. One is the unsafe food, it goes to the criminal court. And in case of small minor violations like a misbranding, substandard, then the cases will be filed before the district ADM, additional district magistrate. Under section 68, says that every district shall have an adjudication officer. The adjudication officer will be the rank of additional district magistrate, and he exercises the powers of a quasi-judicial authority, and he has the power to compound the cases. Depend upon the nature of the cases, it's a penalty lies from 2 lakhs to 5 lakhs. Same the proceedings, he has to give an opportunity to the food business operator to defend his case, and he should see that in case of misbranding, he need to see how much profit this food business operator has made out of this misbranding or out of this adulteration, and the proportionate penalty has to be levied considering his profit made from that violation. And any penalty will be recovered for the revenue under ROR. So is there any, if you ask, is there any appeal against the adjudication officer? Yes. Every state has a FSAT, Food Safety Appellate Tribunal. In case some state doesn't constitute a separate appellate tribunal, they have notified certain district courts which are equivalent to which has been acting as a food safety appellate tribunals, and certain states has FSATs. Certain states have doing very good work disposing the case expeditiously, and everything is online. Certain states have special courts which acting as a FSAT. So is there, if you ask, is there any safeguard for the retailers, or is there safeguard for anything? Yes. Retailers, a small retailer to a large retailer, if they are selling the products in as is various basis from as they purchase from the manufacturer, they have certain safeguards. And every food business operator who sells the product, they have to issue a form of guarantee. Not for the end consumer, it will be between the buyer to seller, a B2B transaction kind of a thing where manufacturer, dealer will sell it to the retailer. So they need to give a form of guarantee which certify that whatever the product they are supplying, that confirm the quality, that confirm the standards as prescribed under the Act. However, it may not possible, but there are thousands of transactions happen every month, and every time is it not possible for taking this kind of guarantee. So law also provides certain exemption to this. Whatever the year invoice, nowadays everyone issue a GST invoice. Even who doesn't come under the GST, they also issue an invoice. Whatever the invoice and whatever the receipt issued by the seller, it will be deemed a form of guarantee. It doesn't require it if it is in the form E, what mentioned under that, that is well and good. If unable to do it, then the receipt itself can act as a form of guarantee. So there are certain duties casted on this food business operator. They need to ensure the safety, and they need to see all persons who are working under this food business establishment. They should not suffer from any contagious disease. They should have a food handler certificate. They need to undergo certain medical examinations. So, and they also have the first in, first out. Whatever the food business operator received first, they need to sell that first, not in order to have a longer shelf life. So there are certain, as I said, the food business operator, instead of straight away filing in prosecution, launching a prosecution, he has power to issue an improvement notice. This is one of the important thing. Nowadays, major food business operators are the companies. Like in any other act, any non-conformation, any non-compliances or any violation under the act, all the directors are responsible, or all KMPs, every person who is in charge of the affairs of the business are responsible. However, as said earlier, you have the opportunity to file a nomination. You can nominate one person for one state, or one person for one store, or one person for the entire company. You can nominate, but he'll be the primary responsible. He has to ensure that all the compliances as per the act. So these are the penalties. It starts from minimum 2 lakh, 1 lakh to 10 lakhs. In case of death, it's imprisonment as well as penalty. So even if you operate a business without a license, there is an imprisonment up to 6 months. So the law, on one hand, it facilitates and safeguards in case of minor violation. On the other hand, if it is a repetitive violation, if it is a serious, grievous injuries happen to the consumer or any other person, then a stringent punishment up to 6 months imprisonment. Now, due to shortage of time, I'll straight away take you to this package and labeling regulation. If you see any product, if you visit any store, if you buy any product, you just check this product. This product will have all these declarations. Why this required? These are the mandatory regulations under labeling and display regulations. Earlier it was packaging and labeling regulations. Now it is labeling and display regulations. So in any product, every pre-packaged product, what is pre-packaged product? Suppose you go and buy, in present someone is buying, someone is measuring and packing. That's not a pre-packed commodity. What is pre-packed commodity? Which packed in the absence of the consumer. You take any famous brand biscuit packet, it is already packed before you are there. So what is there in the packet? It doesn't know unless you see the labeling regulations. What does labeling regulation conveys to you? It conveys what is the name of the food, how it is manufactured, whether it's making any claim of, say, some kaju biscuit, a cashew biscuit. So what extent of cashew is there? What are its ingredients? And another thing is nutritional panel. If you consume 100 grams of this biscuit or this particular product, how much energy you give, how much energy you will get. So as per National Institute of Nutrition, a 60 kg average person required in India 2000 kilocalories. So this is the recommended dietary allowances. So this is the benchmark. So all these products being compared to that. So if you take what is your minimum RDA in terms of energy is 2 kilocalories. What you require in a day, 67 grams of fat and 22 grams of saturated fat. So all the sugar and all. So how much you will get from this particular product? So the declaration will come. It's mandatory to be declared on the product, and you need to see. There is a tolerance on a that can be a 10% variance from whatever declared on the label as actually physical composition. So another important thing, veg logo and non-veg logo. Earlier, veg logo and non-veg logo appearance was color was different, but appearance was same. So there was many complaints or suggestions from color blindness people. So they can't able to identify. So recently they have changed this non-veg logo to a triangle uh, for the benefit of the people who are suffering from color blindness. So in case if you are adding any kind of flavoring substances, whether it's artificial or natural, you need to mention this, and you need to mention the complete details of who's the owner of the brand, who's the manufacturer. In case the consumer has any complaint, so where he need to go? He doesn't need to go over all states, or he doesn't need to search in the Google to get the details of the consumer. It's mandatory to declare the email or mobile number, email or the phone number of the concerned grievance officer or the complaint redressal officer. So in case product is imported in India, the country of origin has to be mentioned mandatorily. So date of expiry, we need to mention if you see any product, if it is a product up to a shelf life of 3 months, you need to mention the date of expiry also. If it is the product shelf life is more than 3 months, the law says that it is sufficient if you mention the month and year of expiry. Nowadays, this new labeling regulations has come from the restaurants. Some of these we talked earlier about the packaging regulations. But if you happen to visit any restaurant and all, so he doesn't know that when is manufactured, what is the composition, what are the ingredients and all. So recently they started with the menu labeling. So all restaurants which operates more than 10 units and which have a central license, they mandatory declare the nutritional ingredients, nutritional panels as well as the ingredients. So these are the list of the entities which come under the ambit of these regulations. So this has to be displayed in case of a restaurants, in case of a 5-star hotels. On the food, suppose your buffet is being served, so it's mandatory that if it's a 5-star hotel having a central license, they need to mandatory display all this, whether you have allergy information or calorific information, what is your serving size. So if it is a, suppose you take they have given the example, this is example from Food Safety Authority only. If it is a paneer butter masala, then how much calories, what is the price, everything you need to declare. And if you have any allergy, you also need to mention that allergy. This is the mandatory information. And most importantly, the size will also prescribe the size of the letter, how much the letter should be there. If it's a big package and you have only 1 mm size, you cannot see. So your height of the letter, your size of the letter should corresponding to the area of your package. So that also has been displayed. Of course, this is the interface between food safety and legal metrology in this aspect. The both have the same. There are certain exemptions, small packets which less than 100 square centimeter in area. Area means entire area of the package, then doesn't require to have the entire mandatory declaration. So there are certain industries which require to have a food safety audit from a third party. There are certain under audit regulations, there are certain entities which has been identified for the audit regulation. They need to mandatory conduct once in a year. These are the industries. If it is a dairy industry, a fish industry, meat industry, egg industry, or a catering industry, they need to conduct audit once in a year to a third party. So this is all about food safety, and The primary concern of this entire act and legislation is to ensure the customer safety. First, we all are consumers, then we are lawyers or we are any other profession. But before that, we are consumers first. And in the safety of the consumers, as it's a directive principle, say that it's a duty of the state to provide safe and nutritious food to the citizens of the country. As I said, in the Center for the Interest of Public Litigation, Supreme Court says that this is the inalienable fundamental right that that citizen or the consumer will have a right to safe and quality food. So with this, I thank you, Vikasji, for providing me this opportunity. And if you have any specific questions, I am here to answer this.
Yeah, thank you, Srikanth.
Thank
The
you.
way you explained it in a more subtle manner, I was just reminded, just like Krishmachari Srikanth used to come and bat and perform, the same way you performed it. We can do away with this screen. Meanwhile, Joseph Khan says whether seized items should be made as in terms of Section 100 CRPC. Is it mandatory or directory? Kindly explain.
Sorry, sir. Sorry, sir.
He says whether seized items should be made as per Section 100 of CRPC. Is it mandatory or directory?
So it's not mandatory, it's only directory.
And then there's another question. How to test a crushed groundnut oil? For that matter, any other oil?
So groundnut oil, the standards has been prescribed. For testing, it has to send for the analysis. So oil, it takes minimum 2 to 3 days for completing the analysis. So there is no, like you have a milk test kit, you can straight away test the milk solids. What is the milk solids in that milk? Similarly, in case of oil, it has to go for analysis, and there's a method, evaporation method. They'll conduct the method. Then only can able to assess what is the propensity of the oil. So there is no fastest route to test the oil. That is the reason that loose oil has been banned more than 20 years. So entire oil, edible oil, has to be sold in only packaged conditions.
This is why. Can these tests be done in a private laboratory or there are some standard laboratories?
There are two times. One is if it is a surveillance sample, it has to be, the food safety officer has the right to send it to the accredited lab, if it is a government or private. But in case of a customer, as a consumer, you can also collect and you can also send the sample to the analysis. You can send it to any NABL lab. More than 80, around 80 or 81 labs has been accredited so far. You can send it to anyone. It should be accredited by NABL and approved by Food Safety Authority.
So we take a step forward. How will the seller come to know that, or the manufacturer come to know that the product which the consumer is sending, what will be way forward for that, for sealing and sending it to the laboratory? How does it ensure that there is no tampering with while sending it to the laboratory?
That is the reason you need to have this independent witness mandatory. So first of all, any sample being collected, if it is a packed condition, then law is very clear that it has to be sealed and send it. But in case of loose commodity, as I give an example of a milk or anything, if you need to collect from the open vessel, then it has to be in the presence of independent witness. It has to be collected homogeneously. There are many cases. I have these volumes behind me. Before the Supreme Court, milk was not collected properly. Or curd was not collected properly. So there's a process that you need to steer the entire commodity. Then you take the homogeneous product.
Last question is whether there is any nominee under the FSI, why authorities register case against store manager, company and the nominee?
Now, in case of a valid nomination, the food authority has no other chance except to make him a party. Sometimes what happens is they'll also make other parties, especially in the directors, in order to bring seriousness. So they make the party. But law is very clear. If it is a nominee and nominee is valid, the only thing what you need to see this, the nominee is valid nominee. The moment I say that, he should be in a capacity to take the decisions and control the activities. He has the power to implement the food safety quality process in his store. Unless he doesn't, suppose I, for the sake of nomination, I appoint someone who doesn't even have any authority, is the lowest person in the store, then it doesn't valid, it doesn't hold valid. What is a valid? The person should be in a capacity who can take the action to ensure the compliance of the act. If that is there, it is mandatory. Only the case will lie against the nominee.
Yeah. How to collect the oil sample, please? Nandini.
So oil sample, though nowadays, as I said, it's only packed condition. There is no need to open it and need to collect this. You collect the package, packed, take any brand oil or any unbranded oil, it has to be in the form of a packed only. So pack it, seal it before the independent witness, and there is a process how you need to seal. You need to take a container should be clean and dry. If it is a glass jar, you need to wipe with a dry cloth. You need to put the product and you need to seal with a twine, and you need to send the sample to, if you, as a customer, if you are selling this, you send it directly to one lab and send it one to the DO.
Rakwa Sharma, who is the competent authority to release seized goods which were seized simultaneously with the collection of sample?
A designation officer. Designated officer, he is the authority. In case designated officer is not responding or is not doing, then Commissioner Food Safety.
Last question. Any limit on number of items that FSO can take as a sample for analysis?
Actually, there is no limit under the law, but as a practice, you should take 2 or 3. But there are instances, especially before festivals, if there are, I have seen the case that they have taken 4,000 rupees chocolates also, whereas you need to take only 400 gram chocolate. But yes, there are cases that they're taken more also. But you need to show that regulation 2.3.1, it clearly says that you need to take the specified quantities. So whatever the quantity mentioned there into 4, he can take. He has to take.
Yeah. Thank you, Srikanth, for sharing your knowledge. The most fascinating part was the participants who were on the Zoom and the YouTube. They were the total same. Maybe in the YouTube they got up. So it means those whosoever had joined the Zoom link, they were totally logged up. It seems that you had put the thumb on their feet so that they couldn't move and just they were glued to watch your videos. Thank you.
Thank you, sir.